Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. Today I'd like to talk about the things that are important in determining the divorce settlement, which may be counterintuitive. And by counterintuitive I mean, without guidance one may have thought that the rule is the other way, but it turns out not. Let's talk, for example, about the family business. A lot of people think, and I know this because I get the question all the time, that if something is titled to one spouse, it necessarily means that the other spouse doesn't have an interest. Or if they have an interest, it's a very small interest. And why? Because everything is titled to one person. Everything is designated already in the form of ownership to one individual, and therefore in a divorce it doesn't get split. Well, I'm here to tell you that that's a perfect example of something that's counterintuitive, because in the divorce world, that's not the analysis. Really, the analysis is not about what or about in whose name. The analysis is when. When did the thing that we're talking about come up? When did the asset that we are discussing come into existence? If that thing, if that company, if that enterprise came about during the marriage, then it doesn't matter if it's in your name or his name or in Mickey Mouse's name. None of that matters. You know why? Because it came up during the marriage and therefore it's a marital asset. And because it's a marital asset, we got to divide it. Odds are we're going to be dividing it equally or equitably as determined by the court, but it's probably going to be split, and the split's probably going to be 50-50. So it doesn't really matter if it's in your name or his name. It matters, did it come about during the divorce? And that becomes important, because suppose we have a family business that was in the family many, many years before the marriage. Maybe it belonged to your husband's father, and maybe he passed away and left the business to the son. That's a little bit different. Then we have to look at certain things. We have to look at the value of the business before the marriage. A day before the marriage, what was it worth? If it was already worth a definable sum of money a day before the marriage, that amount of money arguably is off the table. That value, that asset belongs to him. Why? Because it was accumulated when? Not during the marriage, but before the marriage. However, maybe the business was worth $1 million before the marriage. Now it's worth $1.5 million when we look at the divorce. There's an argument to be made there that the increased value is something that accumulated when? During the marriage. And therefore that increase in value, maybe that's subject to division. It's going to depend on certain things and how the court looks at the overall financial package as we discuss resolution of the assets in the divorce. But you do have to understand, again, look what we're doing. We're not analyzing in whose name something is. We're not looking at who created it, who brought it into being. We're looking at when it was brought into being. If it's brought into being during the marriage, it's clearly on the table. If it was brought in before but it increased value, there's something to talk about, at least to the extent of the increase. Every now and then we get a situation where an old asset that existed long before the marriage is 100% a marital asset. Now, how does that happen? And the answer is it happens when the person who owned it gifts it to the marriage. Let's say, for example, there's a house. Your wife owned a house way before the marriage, but after the marriage she quitclaims it from herself to herself and you, the new husband. 10 years later you get divorced. Is that house a marital asset? Strong argument that it is. Why? Because even though it was separate, it was gifted to the marriage. Again, we're always looking at when the asset became what it became. If you have any questions about that, reach out and we'll be glad to help you out.